The next case is Agarwal-Hartung versus Agarwal. Both sides ready to proceed?
Yes, Your Honor.
Each side will have up to 15 minutes to present their argument. The appellant may reserve up to 5 minutes. You just need to alert me as to the time you need, and I'll try to save that for you. Also, I would alert you to the fact that there is a monitor up there that also tells you the time. It may be helpful. Okay, you're ready to go. We're ready to hear. Thank you so much.
Good morning, Your Honors. I am Jessica Bacon from Bevin & Associates, and I represent the appellant Buddy Hartung in this case here today against Dr. Agarwal-Antal and Hartung Dermatology. This case today is a negligence case.
Before you go any further, did you want to send this?
Oh, I'm sorry. Let me save 2 minutes. Thank you. This is a negligence case in which a doctor skilled in her field of dermapathology stepped out of her skill set and performed a procedure that she was not skilled in, a cosmetic procedure that resulted in harm to her patient, Buddy Hartung. Prior to November 2015, Buddy Hartung had treated with Dr. Antal numerous times for many years, and there was never a problem. And what's important about that is that all of her previous procedures that related to cosmetology in any way were pre-mixed, pre-boxed facial chemical peels that required no intervention or mixing or really decision-making by Dr. Antal. The strength of the acid in those peels, Dr. Antal referred to as mild. In November 2015, a new procedure was attempted. It was a new procedure for Betty, and it was a new procedure for Dr. Antal. In her deposition, Dr. Antal told us that she could not recall a situation in the past where she had used a TCA, an acid peel, to treat sunspots on someone's arms. So this was new for everybody. This day, Buddy Hartung signed a written consent to have a TCA less than 35% strength used on her arms. But what transpired that day was a 35% TCA being applied to her face, her hands, and her arms in multiple coats. While this application was happening, Buddy was screaming in pain. Her screams were so severe that her staff, Dr. Antal's staff, added in the notes that they feared she was having a heart attack. Today, almost 4 years later, Betty still experiences extreme sensitivity, burning, and reddening of her body where this acid was applied in multiple coats. Her injury is not one that is visible all the time, and in fact, one of the ways she deals with it is to keep those areas covered all of the time. But there are multiple sets of photos that were part of the record showing her arms at different times and showing that injury. There are 3 medical professionals involved in this case on the plaintiff's side. The first was Dr. Gregory Klassen, a local dermatologist. Dr. Klassen reviewed the records from this case and provided the initial affidavit of merit that was filed along with the complaint.
Counsel, is that affidavit of merit, can it be attributed to the plaintiff's evidence in the motion for summary judgment?
We didn't. I believe it would probably have to be amended a little bit to be an affidavit that complies with the requirements for summary judgment support. We did not attach the affidavit of merit as an exhibit to summary judgment. So I'm not sure how that would have played out if we had. We used the second doctor's report.
Okay, so that particular doctor was not depoted, correct?
Correct.
Okay, but parts of his report were part of another doctor's?
Correct.
Okay.
That's correct. And his, Dr. Klassen also did an examination of the plaintiff very early on in this case and he diagnosed her with her injuries from this peel, which were hyperpigmentation and hypersensitivity as a result of this application. So Dr. Klassen's medical opinions as they relate to proximate cause and even to standard of care in this case were disclosed to the defense very early on. It was part of our written discovery. We gave that office note, and Dr. Klassen was, he's local, he's 10 minutes from my office. And he was never deposed. He was never requested to depose him. Plaintiff then was in a situation where Dr. Klassen had mentioned to me that he was looking to retire soon. He had asked me about a timeline for this case, and I can never really give an accurate one. So plaintiff sought out another expert, Dr. Ehrenreich in New Jersey, to review these records and asked if he could provide support. He reviewed the testimony, the deposition transcripts, of which there were several at that time, and he reviewed the records. He reviewed Dr. Antal's notes, Dr. Klassen's note, and provided a detailed report on the standard of care violation after his review. He was deposed, and the subject of his deposition is actually the subject of the trial court order that we're here on today. Dr. Ehrenreich, in his report and in his deposition, he recognized that there was a glaring dispute over the facts in this case. The facts of what transpired as far as actions and conversations in that doctor's office. He noted that there was a dispute of facts between the plaintiff, between the defendant, and between the defendant's assistants who were deposed. He properly concluded that he cannot weigh the credibility of the parties. He cannot say, this person told the truth, this person did not. That was not his job. So what he said was, if plaintiff's testimony is accurate, if the jury determines plaintiff to be the one correctly reflecting what happened that day, then yes, Dr. Antal violated the standard of care. Dr. Ehrenreich's purpose was standard of care, and he fulfilled that. It was made a big deal in dispositive motions, some sections cherry-picked from Dr. Ehrenreich's deposition. And there was a question asked of him saying, based on the photos, you cannot say she suffered an injury from this procedure. And his response was, based on the photos, no. The patient has claimed an injury. I cannot say she doesn't have an injury. She says she has sensitive skin. She says she reacts to sunlight. I can't tell you she doesn't have an injury. All I can tell you is from the photos, I don't see an injury. And that was accurate. Photos that were taken on the day of her deposition inside my office, not in the sun, not in the heat. You could look at her and you don't see an injury. That's accurate. But Dr. Ehrenreich recognized that she was claiming an injury. He did see Dr. Klassen's report, which diagnosed the injury, and he made the conclusion that if what happened is what plaintiff says happened, then there's a problem here. There's a standard of care violation. The third medical professional that I believe supports plaintiff's case is Dr. Antal herself. She was identified as an expert by the defense, and Dr. Antal testified over 2 depositions that she used an acid peel 15% stronger than she had originally planned to use, that she told Betty she was going to use, than she had used in the past, and 15% stronger than she ordered and that she received. And the reason she used this stronger peel was because on the day that Betty arrived for her appointment, Dr. Antal couldn't find the bottle. It had been received. It was in her office because it was turned over months after her deposition as found. But on that day, she couldn't find the bottle. So she used what she had, which was 15% stronger. She had never used it on sunspots on arms before, but she used it, and she used it on multiple coats. Dr. Antal also admitted that Betty did have what she referred to as an extreme reaction. You go for a chemical peel, the thought is you're going to burn your skin. Your skin's gonna burn. But this reaction that Betty had was testified to by her doctor and the assistants that it was extreme. They had not been in a situation like this before in all the years of practice. Dr. Antal also admitted that she added or edited Ms. Hartung's records later on. And that goes to another issue in this case, but definitely her credibility is one that should be determined by a jury. In this case, the trial court accepted Dr. Antal's version of the facts as true, and really they were highly contested. The law cited in my brief is that this court recently created this year in Pearson versus Alpha Phi Alpha Homes. And in that case, this court reversed the trial court's decision as it abused its power when it weighed the testimony of experts. And that's really what I believe was happening here. And when we're talking about the testimony of experts, that's everyone. That's Dr. Antal as well, because she was identified as an expert in this case. And her credibility being weighed should not be weighed as a fact witness, should be weighed as expert testimony. She was offered as an expert and gave testimony clearly above that of a lay witness.
Does it make any difference, counsel, in terms of weighing testimony at the summary judgment phase, whether it's a fact witness or an expert witness?
No, it shouldn't be weighed at all. Thank you. This court, the Ninth District, also ruled in 2017 in Nation Star Mortgage versus Wiseman that a trial court does not have the liberty to choose among inferences in the context of summary judgment, and competing inferences or questions of credibility to be resolved in the non-moving party's favor. In this case, the defendant picked small sections of plaintiff's expert's deposition as its entire basis for saying plaintiff cannot prove negligence. It was error for the trial court to agree. The law requires the trial court to review the entire transcript, and that did not happen in this case. And I cited the 3rd and 7th District cases that relate to that issue. At the end of this, maybe Dr. Ehrenreich doesn't hold up on cross by a skilled attorney as Mr. Rossi. Maybe Dr. Antal doesn't hold up on cross by myself. Maybe the jury doesn't believe Betty Hartung when she comes into court and she looks great, that she was injured. But all of that is not to be determined by the trial court. Plaintiff has put forth testimony on negligence and standard of care, and any analysis of that testimony by the trial court is reversible error, and we ask that you reverse.
I do. Counsel, taking what you say is true, let's do the reverse. Let's say all facts were found in favor of your client.
Okay.
Is the court and your opponent's argument basically that that wouldn't matter because when you have that negligence, one of the elements, final element you need is the damages, and you didn't meet that. So I can take everything your client said as true, just discount everything else, and the argument is you still didn't meet damages.
And I would say that we did meet the damages through the office notes of Dr. Klassen, through the photos, and through the plaintiff's testimony.
Thank you.
Thank you.
Good morning, Your Honors.
Good morning.
May it please the court, my name is Carol Tran, and along with my co-counsel, Attorney Rossi, we have the privilege of representing Dr. Antal in Hudson Dermatology today. And I want to begin my argument with a point that was raised by Your Honor, Judge Callahan, that I believe is the crux of this argument. It's the fact that even if we were to interpret any disputes of facts in favor of the plaintiff, we can't ignore what is said by Dr. Ehrenreich. And this portion of his deposition testimony, I think, is very black and white, and this is the problem that plaintiff has. And it's located on page 68 to 69 of Dr. Ehrenreich's testimony. This is the question and answer. Question: You cannot state that this patient suffered an injury as a result of the care and treatment provided by Dr. Antal in this case. True? Answer, correct. Question, you cannot state to a reasonable degree of medical probability that any negligent act by Dr. Antal caused this patient injury. True? Answer, true. So even if we view all the evidence in a light most favorable to the plaintiff, the fact of the matter is they don't have the necessary expert testimony to support their claims, which is required by the Ohio Supreme Court case of Brady versus Tatsumi. That is the ultimate issue before this court. Whether this court will overturn the trial court's grant of summary judgment in favor of Dr. Antal when she does not have the requisite expert testimony to support her medical claims. The three major claims that she has before this court are medical negligence, lack of informed consent, and punitive damages. There's been a lot of discussion about whether the trial court weighed the credibility of the expert. And if your honors take a look at the orders that were set forth by Judge McCarty on January 9, 2019 and February 28, 2019, there's simply nothing in those orders to indicate that the credibility of the expert was weighed. There's no discussion about Dr. Ehrenreich's credentials or lack thereof. There's no discussion of whether he's trustworthy or not. There's no discussion or suggestion that the trial court simply failed to read the entire deposition transcript. The mere fact that they have cited certain portions from the deposition transcript is not an indication that the entire deposition transcript was not read. But the fact is, credibility wasn't the issue before the trial court. The issue was whether Dr. Ehrenreich was able to provide testimony in support of those four elements under Bruni. And Bruni requires that plaintiff, through preponderance of the evidence, demonstrate the duty of care, that Dr. Antal breached that duty of care, and that there was a proximate cause of those injuries. So we have to focus on the expert testimony that was set forth by the plaintiff. And the only expert that they have in this case is Dr. Ehrenreich. I want to make that very clear. There's been some discussion about Dr. Clausen. Dr. Clausen was never identified as an expert below. He never produced an expert report. The only thing that he provided was an affidavit of merit. Because he was not identified as an expert witness or provided a report, he's not considered an expert for the plaintiff. His testimony was not taken as a result, and anything that he might have said was not entered into evidence and was not before the trial court to consider at the summary judgment stage. The only expert they had identified on their behalf was Dr. Ehrenreich.
But was the doctor's notes before the trial court to be considered by virtue of being part of the expert's notes or deposition?
That was part of the evidence that may have been reviewed by Dr. Ehrenreich as part of his file. His file, however, was not submitted to the court for review at the summary judgment stage, is my understanding. We do not have the underlying expert file of Dr. Ehrenreich before the court. That was not submitted by the plaintiff. So the only expert that they have on their behalf is Dr. Ehrenreich. And we can split the medical treatment on November 20, 2015 to essentially two different body parts. We have first the application of the TCA peel to her face, and then we have the application to both of her arms on the right and left side. And Dr. Ehrenreich is very clear in his deposition that he felt Dr. Antal actually complied with the standard of care with respect to the face. So the face is not an issue. Dr. Ehrenreich concedes that point. So there is no expert testimony to support their claim of injury with respect to Betty Hartung's face. So the only thing that we're left with then are the arms. And I want to make it very clear what his criticism is. His sole criticism against Dr. Antal is if she applied 35% TCA twice to a fully frosted area. That's his only criticism. And the reason I point that out is because there was some question as to whether this was a premixed material or something that had to be mixed up by a pharmacy. Dr. Ehrenreich doesn't have an issue with the composition of the mix, who it was mixed by. He doesn't have an issue with the strength of the TCA peel, whether it be 20%, 35%, 50%. He doesn't have an issue if 2 coats of the 35% TCA peel were applied to an area that was not fully frosted. So his criticism is extremely limited. And at all points, his criticism is always prefaced with the word if. And that's a hypothetical answer. Every time he was asked whether Dr. Antal had violated the standard of care, you can only provide an if statement in response. And that's a problem because that doesn't meet the level that is required of a medical expert. A medical expert has to provide an opinion to a reasonable degree of medical probability to get above that 50% mark. Providing speculative statements, that's something that anyone can do in court. For Dr. Ehrenreich to support their prima facie claim of medical negligence, he has to state to a reasonable degree of medical probability that Dr. Antal violated the standard of care. And if your honors take a look at the deposition transcript, at no point is he able to do that. But even setting that aside, there's still the issue, like I had talked about before, approximate cause and injury. Those are 2 essential elements of a medical negligence claim. And like I read that passage before, he cannot state that Dr. Antal approximately caused any injury in this case. Face, arms, through any means. He cannot state that. And that's perhaps not surprising because Mrs. Hartung did have a good outcome. We had an opportunity to depose her back in April, and she said herself that on both arms, the brown spots that she very much disliked, they were reduced by half. Her face, also the brown spots that she didn't like, they were reduced. Both her husband and Dr. Ehrenreich said there's no scarring, there's no discoloration. She has healed. So there is no injury in this claim, in this case, and that, I believe that is the basis for Dr. Ehrenreich's testimony and inability to provide any testimony with respect to those elements. 2 other issues I want to briefly touch upon that were not covered before is this lack of informed consent and punitive damages. One thing that I want to make sure that this court is clear on is that lack of informed consent is basically a more specific form of medical negligence. According to the Ohio Supreme Court case of White versus Leinbach, which was issued in 2011, we need medical expert testimony in support of a claim of informed consent. It has the same elements as a medical negligence, where the duty is to provide a patient with the material risk and danger of the procedure. The breach is if you don't provide that disclosure, you still need proximate cause and injury. And for the same reasons that I talked about before, we don't have the proximate cause element supported by any expert. We don't have injury supported by any expert. And in fact, Dr. Ehrenreich said himself during his deposition, he's not going to provide an opinion on informed consent. That's not what he was asked to look at, and that's not what he was going to testify to at any point during this case, in a report or at trial. Finally, there's been some discussion through the briefing regarding the issue of punitive damages. A couple of things that I would like to leave the court with on that issue is, first of all, the last time that Dr. Antal went to her note was almost a month before Mrs. Hartung ever picked up the phone and asked for her medical records from Dr. Antal. There's simply no indication that she did anything to her note to avoid liability or lessen her liability. Because the last time stamp that we have on the note is almost a month before that phone call happened. And everyone, even Mrs. Hartung, agrees that when she called up Dr. Antal's office, she said, I would like my medical records for tax purposes. She never told Dr. Antal, I retain an attorney, I plan on filing a lawsuit. That's not what she said. She said, I misrepresented to Dr. Antal that I needed them for tax purposes.
Counsel,
doctor necessarily have had to know that there was going to be some forthcoming negligence suit, or even have an inkling? Should she have been so inclined to go through her medical notes and say, ooh, I don't like the way that one sounds, let me switch it? I mean, does one have to be related to the other?
According to Moskowitz, the Ohio Supreme Court case that discusses punitive damages, one of the essential prongs is to intentionally alter or destroy evidence in reaction or to avoid litigation. So there has to be some knowledge that there might be litigation coming forth. So
How about her screaming in the examining room? Might that be some indication that something could come in the future?
that possibly could be an indication, but I would disagree with those facts. Neither Mrs. Hartung nor Dr. Antal discussed this screaming. They talk about her sitting up, breathing heavily throughout the procedure. Both are very forthcoming that happened. So in terms of screaming, I'm not sure where that appears in the record.
They did put in the medical records that they thought she may be experiencing a heart attack.
Yes, they did. And to remind the court, this is a chemical peel, so essentially it is a controlled burn that's being applied to one's face and one's arms. It is, the whole point, as Dr. Ehrenreich says, of a TCA peel is to cause chemical injury in order to take off that outer layer of skin to reveal the newer skin underneath. So there is going to be some discomfort. And Dr. Antal describes that as something that would be like a severe sunburn. But the other issue with punitive damages is that it's also a derivative claim. So if you don't have a claim for medical negligence, if you don't have a claim for lack of informed consent, you can't have a claim for punitive damages.
I'm still having a little bit of confusion on the lack of consent. So you're saying it was lack of consent that needed a expert's testimony because of what was not relayed to the patient.
So
Because information was not, complete information was not given.
if I'm understanding your question correctly, yes, according to the Supreme Court, expert testimony is required to support a claim of lack of informed consent, if that's what I'm hearing.
Yes, and then, but didn't she also allege just almost like a battery that she had not given consent at all for her face?
And I'm glad that issue is being brought up because battery was never alleged in the complaint.
But did she have allegations that said she never gave consent for her face to be chemically peeled?
So if your honors take a look at count 3 of plaintiff's complaint, it's captioned as informed consent. And the way it sets forth the elements, it mirrors the elements of a lack of informed consent. And I think the confusion comes with, through the briefing that I'm gleaning, is that she is now attempting at the appellate level perhaps to now assert a claim for battery, to which consent would be an affirmative defense that defense counsel could possibly assert in relation or in defense to a consent claim, but that's not the claim we have before the court.
Okay,
It's lack of informed
so, and I'm sorry, I'm interrupting you only because I know we're almost out of time. So you're saying at no time during the summary judgment proceedings or discovery or anything did she allege that the doctor put the chemical peel on her face without her consent?
I think those allegations have been made by plaintiff's counsel through the trial court proceedings, that there wasn't consent for her face.
And you
But
wouldn't need expert testimony on that.
I would disagree with that for lack of informed consent because.
Well, we're not talking about no consent.
I'm not sure I'm.
Well, you can have informed consent if you're given all the information and you say, go ahead and do it, okay? But if somebody just starts putting something on your face and you haven't consented to that, then it's not a lack of informed consent, it's just a lack of consent, period.
I understand what your honor is saying, but the only issue that was considered by the trial court, the only claim that was before the court was one for lack of informed consent, and that is something that expert testimony is required by the Ohio Supreme Court.
Okay,
They were not considering that.
Thank you very much. I put you over time. Sorry about that.
Thank you. So we request that the court affirm the trial court's judgment. Thank you.
And you have, as the monitor reflects, 2 minutes and 4 seconds.
Okay, Your Honors, unless you support and would forego the rest of my time.
Okay, well, thank you very much.
Thank you.
And the court will take the matter under advisement. We'll issue a written opinion that will be sent to both sides. And you also can look on our website, the Supreme Court website, to get really anxious and make it just maybe a hair quicker. All right, thank you very
Thank
much.
you.
Thank you
Thank
all.
you, Your
Have a
Honors.
good day.
All rise.
Oh, no. You get it.
The most important question, can either of us remember all of that?
Probably not.